It's 46 the time now. A landmark ruling at the Supreme Court yesterday could pave the way for more pension freedoms for many, many people. Ben's been looking into this. This is the difference in status between a married couple and people who are partners in relation to their pensions.
Exactly, and ultimately it could come down to just ticking a box on the form when you sign up for it. So we're going to talk about that in just a minute, but it could affect millions of people. Thanks so much. Morning to you. Yeah, what rights do you have to your partner's pension if they die? Well, if you are married, it's pretty straightforward. You automatically get access to it. But if you're not married, things aren't so clear. You're not automatically entitled to claim their pension savings. Well, Denise Brewster lost her partner of more than 10 years, but they weren't married, and she wasn't allowed access to the money that he'd saved. So she thought that wasn't fair, and after an 8-year legal battle, she won.
Initial fight was about fighting for us and what we were to each other. And then I realised that this wasn't only affecting me, this was affecting so many other families out there. So at least I just had to defend for myself and I had to take my hardships. But when you have other families that have a young daughter or son who are losing their daddy or their mummy, and then they have the financial burden on top of that, you know, the inequality and the injustice of it all, I thought was immense.
So that's the view there, having won that case that's been lasting about 8 years. Well, Charmian Johnson is with me. She's from the law firm Eversheds, Sutherland. Good morning. Nice to see you. We've called it a landmark ruling. How significant is it?
I think it is a significant decision. This landmark decision, as you call it, could potentially affect millions of people and really goes to the heart of the inequality of cohabitees.
And the issue essentially is that difference, isn't it? Whether you're living with someone for however long, if you're not married, if you've not got that certificate, then it won't make any difference unless, and this is the crucial thing, you ticked a form on the paperwork. Explain that for us.
Yeah, with public sector schemes, so both UK, Northern Ireland, many of these public sector schemes required cohabitees to fill in a form with their partner and lodge it with the scheme. So in the event of the partner's death, it would be considered, and that would be a requirement in order to receive a survivor's pension.
Now, the rules have changed a little bit since, and depending where you are in the country, things will have changed. But it's a difficult area for people to navigate. There's a lot to think about when you're taking out a pension in the first place. There's really a lot to think about if your partner dies. This is the last thing people need to be thinking about.
It certainly is, yes, and I think that's why this has been a very sensible and understandable decision of the Supreme Court. I think many of these public sector schemes still require surviving cohabitees to show that they were in genuine and lasting relationships, irrespective of filling in a nomination form, and that's why the nomination form didn't really add anything in practice.
And so we have this ruling that came through yesterday. What will that change from now on? Does that set a precedent then?
It does. The Supreme Court is the highest court in the land, if you like. The case in question really related to the Northern Ireland local government pension scheme, but this could affect other cohabitees in UK public sector schemes. So we're talking about NHS staff, teachers, police, civil servants, firefighters. This decision could all be relevant to those who are cohabiting.
What does it mean if people have been through this already, they've not been able to claim their partner's pension when they died? Can it be backdated? Can you claim after the event?
I think now this landmark decision means that the government is forced to revisit past cases where cohabitees have been refused a survivor's pension purely because this nomination form hasn't been lodged.
What would people need to do? How would you even start that process? If someone's watching today says, this is exactly what I went through, I wasn't able to claim my partner's pension, what can they do?
I imagine that the schemes and the government will be considering communicating to all potentially affected members. However, if you are a cohabitee who's been a member of a UK public sector scheme, I would be writing to the scheme and lodging the facts with the scheme that you are a cohabitee, and also for those who have had surviving pensions refused on the basis that no form had been lodged, I would also be bringing that to the attention of the scheme.
And so the onus will be on the industry, will it, that they now have to communicate that, because they'll be looking at how they process some of these claims and also what they do now from here on in?
Yeah, indeed, and that's why I think it's a bit of a headache for the government. There's millions of people in these schemes. It's a big exercise for them, but I think it can't hurt for the individuals who may think they're affected to also contact their schemes and raise it with them.
A really interesting area, and as you said, a really important case. Charmian, really good to talk to you. Charmian Johnson there from the law firm Eversheds, Sutherland. More from me after 7. I'll see you then.